I'm sure if you have been involved with SORNA at all, that you are very much aware of the Supreme Court kind of flipping and turning everything upside down a few years ago. Well, we have two attorneys here today that were on the forefront of all of that. They're going to help us understand those cases and let us know where we are and how we are going to move forward. So enjoy the next panel. If you have a question, please raise your hand, and then one of our staff members is going to come to you with the microphone. We want to try to capture everyone on the microphone so that when people go back and listen to the recording, they can hear everything that's being said. All righty.
Thank you.
Thank you.
Are both mics working?
Yes.
Okay, great. Good morning, everyone. My name's Carson Morris. I am in private practice now. If you want to show them my slide, you can see my dead behind the eyes look that my wife never ceases to remind me about. But I was at the Attorney General's office for 4 years, and I left in January. I had the good fortune when I was there to be involved in the post-Muniz litigation fallout that, sort of, was obviously a huge deal in many of your worlds for many years. And we'll get through all this, but that was one of the highlights of my legal career, working with all of the extraordinary lawyers that work with you guys was a great highlight. Tracy, do you want to introduce yourself?
Sure. Hi, I'm Tracy Piatkowski, and I am currently at the Attorney General's office. I thought I was going to be Carson's sidekick when I got there, and then it ended up he left. So I'm taking over for him. But I was, before I came to the AG's office, I was in the Montgomery County DA's office for about 3 years. And before that, I was in the Philadelphia District Attorney's office for 14 years. And I never actually did these kind of cases pretty much ever until one day my supervisor, the head of the law division, knocked on my door shortly after Muniz and said, we've got some issues and we need to put someone on this. So I sort of became the person. So when I went to Montgomery County, and we ended up having a couple cases in Montgomery County that ended up working their way up to the Supreme Court, I was the natural choice to handle those. So, yeah.
Okay, quick caveat. Me and Tracy both reminded ourselves of this repeatedly. This is a very complicated statute, and these issues are not, as always, clear-cut as they may be presented by us. I think we're going to give you guys a pretty good understanding, but just make sure you understand that you're probably going to have questions, and if you do, obviously there's a lot of really smart people around you that can help you. But we're going to do our best, but I can promise you that every one of these opinions and all of these issues, there are all these little side issues and questions that are still sort of remaining. But I think that you're going to have a pretty sound understanding. The other thing is, I personally have sat through so many video CLEs that I'm ready to blow my brains out, frankly, watching one person talk uninterrupted for like an hour and a half. So we hope this is an interactive event. Tracy and I are going to try and mix it up. Anybody has a question, please raise your hand. We'd much rather have this be interactive than just us up here droning on for an hour and a half.
Yes, and if at any point we're going too fast or you didn't quite follow something, please feel free to raise your hand and ask, because we've been sort of studying this stuff for years and still don't quite always get everything, so it's complicated.
And I just think before we get started, I want to express some appreciation on behalf of me and Tracy. When I started doing these projects, and I got involved kind of right after Muniz. I was working with the trial attorneys in the OAG. We were kind of confronting the reality, trying to understand what had happened, and intervening in cases and just getting our foothold. I reached out to Jen Storm, your former colleague, about the possibility of the OVA and filing an amicus brief in one of the cases. And she shared with me an episode where part of the opinion is there's language in it about shame, whether registration is comparable to colonial era shaming. And we had this fascinating conversation where she talked about how shame was such an important part of the experience that victims have. And the irrationality of shame, that's such a huge part of what they work with victims of sexual assault. And it sort of lit a fire in me. The work was fascinating, and I was all in. But it showed me how that there's this whole other side to registration that's really should be the focus, right? Victims and the public. But in the constitutional analysis, a lot of times that just gets lost. Typically, the way things work is the constitutional provisions in question are really focused on defendants. That's sort of the root focus of the analysis, and then it becomes a very technical kind of discussion. But in the end, what it should be about, and what we try to impress upon the court over and over and over again, is that what really should matter here are victims. What really should matter is the public interest in having these important statutes in place. So again, it was really our involvement with all of you and the attorneys that you work with and the leadership in your organization that were such a huge part of the entire Commonwealth response to these cases. We'll start. Oh, I think you skipped. Origins of registration statutes, or did I skip? Sorry, guys. All right, my bad. Okay, so we think it's helpful to start with the idea of, a big societal backdrop. And this was going on sort of at the beginning of 2017 when the Muniz opinion came down, and then during the course of the litigation. And something that happened was the Me Too movement. And there has been a shift in the public perception, I think it's fair to say, about the reality of sexual assault in our society. You had the OAG's report on the Roman Catholic Church. I was a part of that project, which had worldwide implications. There just seems to be a never-ending revelation of different prominent public institutions that have had a history of very serious sexual assault and sexual abuse. And this is a very short list, and it's unfortunately a lot longer than that. Southern Baptist Church, Boy Scouts, gymnastics, all this stuff, it kind of goes on. And it doesn't seem like every couple months there's a new revelation. Public figures, obviously, Bill Cosby, Harvey Weinstein, many, many, many others, some of whom were criminally charged, many of whom were not. There's also the reality of the prevalence of sexual assault in our society. Statistics, which I'm sure many of you are familiar with, 26.4% females, 6.8% of males, age 20 to 24, experience some form of sexual assault. It's actually higher in women who are not in college campuses, which is kind of interesting. 20 to 32% are reported to law enforcement. And then you, meanwhile, have this really interesting criminal justice debate going on in our society, which seems to be every single facet of the system is under a kind of a really interesting public debate, right? You have bail, capital punishment, that's been going on for a long time, but certainly now. Long-term periods of incarceration, racism in our criminal justice system, policing. I mean, this is something that's really in the forefront of our society, and included in that is sex offender registration. For a long time there has been, I think it's fair to say, somewhat of a boogeyman kind of view about sex offenders, but now there's a pretty significant push to have a different perspective on that. I mean, can't tell you how many New York Times and New York articles I've read about, the horrors of civil commitment, for instance, right? So there's part of that debate in our society about criminal justice includes a debate about registration and sex offenders, but then there's sort of a collision there, right? I mean, you're recognizing the fact that there's this very real problem with sexual abuse and sexual violence in our society, but there's also this counter kind of movement against what are oftentimes characterized as sort of punitive or overly punitive criminal justice, methods, right? So that's an interesting, and many of the people that will be sympathetic to both sides are the same people. So it's an interesting sort of intersection. And in the backdrop of all the court cases and how people should understand the law is this social reality, right? Because the courts are part of our government and they're not immune and completely separated from it. And it's helpful, I think, in litigating the cases and understanding how they work in the courts, is to appreciate the fact that there's this sort of societal backdrop going on. And then we'll start with the origins. It's always helpful, the origins of sex offender registration statutes. And I'm sure many of you are familiar with the murder of Megan Conca. In 1994, Megan Conca, age 7, was raped and murdered by her neighbor in Hamilton Township, New Jersey. The offender had 2 prior convictions for sexual assaulting young girls. He had maxed out of the criminal justice system. So there was no way for the state to do anything about the threat that he posed to society. Probation, parole, all of that had been exhausted. The tether between him and the government had been cut. And his neighbors were unaware of the fact that he had a violent sexual history, which facilitated the commission of the crime against Megan. This sort of triggers a wave of sex offender registration statutes around the country. There had been, you want to switch? There had been those kinds of statutes kind of piecemeal here and there, but it initiates a sort of an effort to try and have some level of uniformity and again, a trigger right, basically every state in the country starts to have some sort of form of a Megan's Law. And that takes us to the purposes of Megan's Law. And this is actually, I've read the debates from when the Pennsylvania General Assembly created their law, and it's reflected even in those discussions from the old days. And these are public safety statutes. And some of these concepts we'll talk about are gonna echo in the case law and how the debate occurs in the courts. But we're talking about public safety statutes aimed at informing the public that a sex offender resides in their community so they can make informed decisions and protect themselves, their family, and others from the risk posed by the offender. It's helpful to think of these as information sharing systems, and that's in contrast to probation and parole, where the idea is to have actual affirmative control and restraints on the individual to try and address the risk that they pose by influencing their behavior effectively. Now, jurisdictions also will employ different types of mechanisms to deal with a heightened risk from certain offenders, sexually violent predators here. A little under half the states, I think it was half, if I remember, have some form of civil commitment, as Pennsylvania does under Act 21, which we'll talk about a little later. That's a very different program from the other ones around the country. But there's just beyond the mere idea of registration, sort of like a database where people can have information shared. There are also more affirmative types of controls that states will assert on sex offenders outside of the criminal justice system, or the punitive type criminal justice controls. And that's basically the way that society starts to develop some mechanism to address the risk posed by sex offenders.
Okay, so in the 90s, every state, including Pennsylvania, enacted some form of a Megan's Law. However, they were all different, and the states were doing different things, so the federal government wanted to streamline that. And so in 1994, Congress enacted the Jacob Wetterling Act. And I don't know if any of you guys are familiar with Jacob Wetterling. He was a little boy who I believe he was 11 years old, and he was with two friends in the town, I think it's called St. Joseph, Minnesota, kind of a rural town, and they were going to the Tom Thumb to get a video. And on the way back, there was a man who's actually, I think it's now 2016, was actually finally arrested and charged with the crime. But he was kidnapped, and it was, I think, one of the biggest, if not the biggest, sort of national manhunt for the kidnapper in the history of the United States. So it was a huge case, got tons of media attention and media scrutiny, and that led to the Jacob Wetterling Act. So to encourage compliance with the standards that the federal government passed, Congress conditioned 10% of federal funding for state and local law enforcement on certification by the Department of Justice that the state's version of Megan's Law conformed to the Wetterling Act and its guidelines. And that is something that you'll see becomes important later on as we move forward, more recently and with Muniz, because one of the things that we'll talk about a little bit later is the internet provision. That is sort of a key feature of the federal registration system that states have to have. And so that's an area where the courts have been struggling, and it's a point of contention. So then the Jacob Wetterling Act was replaced by the Adam Walsh Child Protection and Safety Act, which is typically just called the Adam Walsh Act. And that expanded the Wetterling Act, and as you can see in the slide, by increasing penalties for failure to register, expanding the list of registerable offenses, and establishing a tiered registration system. And as Carson said too, it's just important to keep in mind that, again, the purpose of these statutes, the purpose of the Adam Walsh Act is about community protection through information. And in fact, I looked at the declaration of the purpose for the Adam Walsh Act, and it's really interesting and kind of sad because it has a list of, let me see, 17 people who were, assaulted and or murdered by offenders. And the thought is, if we could have information about these people available to the public, then maybe we could avoid some of that. So just some key terminology for what we're talking about today. Sexual offender is an individual convicted of a crime that obligates them to register on a publicly accessible sex offender registry. The term of registration is determined by the offense of conviction. So it's not based on some sort of assessment afterwards. What you're convicted of has a set term according to the statute. And registration is required. Individual risk is really not a consideration. There is with sort of an exception to that being the sexually violent predators. And failure to comply with registration requirements is a separate criminal offense. So the sexually violent predators are people who've been determined to have a mental abnormality or personality disorder that makes them more likely to engage in predatory sexual offenses. And in Pennsylvania, and sort of generally, sexually violent predators are subject to additional required registration and counseling requirements than the regular non-SVP sex offenders.
Victim rights.
Okay. So, who gets notice under the statute? If an offender, and now we're talking about the current statute. If an offender is an SVP, law enforcement, or in Pennsylvania, the Office of the Victim Advocate provides written notice to victims within 72 hours of the initial registration, and then provides notice when the registrant, when the SVP has to go in and update. So, I don't know if we included in our slides anything about the specifics of registration. Are people generally sort of familiar with the basics of the statute in terms of what offenders are required to do? Or should we go over that sort of generally? Would that be helpful? Anything?
Okay.
So, basically, under the current statute, regular non-SVP, I shouldn't say regular, but the offenders who have not been deemed to be sexually violent predators have certain registration requirements, depending on when their offense conduct occurred, ranging from 10 years up to lifetime. And sort of in very general terms, they have to go into the state police and register basic things like their address, any employment, if they're in school, have a photo taken annually. And again, this is very general. The statute is very specific. It depends on when you committed your offense, what the particular offense is, but that's sort of the general concept. And then that information is placed on a website and is available to members of the public so they can look at it and see who might be in their neighborhood or going to school near them or whatever. And so they are required to verify their information generally annually. So with respect to SVPs, victims will get that notification whenever they go in and update like if they move or if they just have to go in for a regular update and get a new photo, the victims and survivors can be notified. And the notice includes their name, where they reside, where they work, and their school. And that includes things like changes in enrollment. So if they weren't in school and then they enrolled, the victim would be notified of that. And it also includes information related to offenders who are transient, meaning people who don't have a stable housing situation. And sometimes they're even homeless. And those offenders are still required to come in and provide information about where they hang out on a regular basis, where they're generally residing, if they're in a homeless shelter, stuff like that, so that people can be notified. Victims can opt out of this notification process if you want. And for non-SVP offenders, victims are there's no mechanism in the statute other than with reference to the Section 201 of the Crime Victims Act, which is the Crime Victims Bill of Rights. So the notification in this statute really only pertains to SVPs. That's the only notification that's required under the statute.
But there is a mechanism to the website
Yes.
where anyone can flag offender information and various other forms of information so that they will get updates. So it doesn't matter if you have any particular connection, at least within the criminal justice system, to an offender. So if you're a victim, the mechanism, whereas you could keep track of your offender, and assuming that he or she is not an SVP, is afforded through the Megan's Law website. Although it's just not statutorily mandated that the OVA or local law enforcement notify the victim unless it's an SVP. So the resource is there, but it's just not in the statute.
Right. Right. So the statute requires notification for SVPs, but there are other mechanisms for victims to be notified. Exactly.
Correct.
Can you guys hear me okay? Yeah.
All right. Okay, so we're going to start talking about the cases, and so that's going to be helpful to talk about the concepts and constitutional provisions. So what we've been talking about and what registration is and what it generally is around the country is a collateral consequence of a criminal conviction. So if you get a DUI, you lose your license. If you have certain offenses, you can't own a firearm. Those are not part of the criminal case. They're not criminal punishment. Criminal punishment are the sort of traditional modes of punishment that go back, and good Lord, I can't believe it's like all rushing back to me. It's a little shocking, frankly, a little traumatic. But the idea is that, you know, even since the founding of the Bill of Rights, frankly, the constitutional provisions going back hundreds of years are the ones that are supposed to sort of be the model for what constitutes criminal punishment. So you're talking about probation, parole, fines, and incarceration, just to kind of put it in a nutshell. But that doesn't mean that the government can't come up with other collateral consequences from a criminal conviction, and that is what registration has traditionally been treated as. But that was the key issue in Muniz, and we'll talk about that. Because if it's punishment, criminal punishment, then a whole slew of constitutional provisions apply. Ex post facto, cruel and unusual punishment in the Eighth Amendment. Whether ex post facto, we'll talk about with Muniz. The Aprendi Rule, this was the Butler issue. So if a court is going to impose punishment, then there are limits on the fact finding that can be reached in order to increase someone's punishment. So the idea sort of is that if there's a maximum sentence that can be imposed, and there are facts that can increase the sentence beyond a certain level, and also or a mandatory minimum, that has to be submitted to a jury and found by a reasonable doubt standard. And so if a judge is doing fact finding, and as a consequence of that fact finding, it increases the maximum punishment that a defendant would encounter, that would violate what's called the Aprendi Rule. And it's sort of this nexus of constitutional provisions that control that. So the problem was, if you're an SVP and you have a 15-year registration period, but then you're bumped up to life, if registration is a crime, or I'm sorry, it's criminal punishment, then that would violate those constitutional provisions. Does that make sense? Kind of get some nods. So again, those are sort of the key constitutional concepts that were at play when we were arguing a lot of these cases. Ex post facto, the Aprendi Rule, and then the defendants would typically roll out a whole bunch of other arguments involving criminal punishment, none of which probably had a lot of traction with the courts, but they were raised, and the court kind of never got there because they ended up ruling on other parts. But that's kind of the idea. If it's criminal punishment, it's a whole new world, and the fact that it's been treated as a collateral consequence over the last 30, 40 years is a major problem, because the system assumes it's collateral consequence. If it's not, everything kind of falls apart. The reputation clause, this is an interesting facet of Pennsylvania law. Pennsylvania Constitution, Article 1, Section 1, which is kind of like the Bill of Rights, sort of the inherent rights of mankind, includes reputation, along with life, liberty, property, and the pursuit of happiness. And this is an interesting feature of Pennsylvania law. And generally, there is a sort of reputation right, due process right under the federal Constitution and in other states, but it's called stigma plus. So basically, if the government does something that harms your reputation, plus there's some other tangible consequence that comes from that government action, then you might have a constitutional claim, right? But in Pennsylvania, all you need is your reputation. And we'll talk about that a little later. It's a very kind of strange concept. I mean, what is a reputation? Anyway, these are all sort of nebulous philosophical concepts. But the idea is the government making a determination that affects your reputation? And in Pennsylvania, that gives you constitutional rights and the right to arguably challenge that government action. And we'll get into that in a little bit more detail. And the classic example is the diocese of where the court said you can't issue a grand jury report that says a bunch of priests sexually abused and raped children without giving them some higher degree of due process, meaning challenging the opportunity, all that sort of stuff. So that's sort of a concept in Pennsylvania law that's at play in all these cases. And then the standard review. Statutes presumed constitutional, burden on offenders to prove it's clearly, plainly, and palpably violates the Constitution. The idea being that there's an extremely high threshold if a court is going to invalidate a law, and that's supposed to be, obviously a significant obstacle that defendants have to overcome in challenging these statutes. Just a real quick, brief history of the laws in Pennsylvania. Megan's Law 1, 1995 to 2000. It was much more limited. There were only a fewer offenses. Everyone was either a 10-year, you were assumed to be a sexually violent predator, and it put the burden on the defendant to prove that he or she wasn't. That ended up being found unconstitutional in a case called Commonwealth v. Williams. So basically they had to kind of redo, and they came up with Megan's Law 2. Megan's Law 2 was around 2000 to 2004, and then something that essentially mirrors what we kind of have today, the same sort of model. 10 years, 25s, or life in registration, based on the underlying conviction. Everyone had to be evaluated as an SVP. Basically the system has been the same with SVPs ever since Megan's Law 2. And that was in place until Megan's Law 3, 2004. And this was what was prevailing for about 8 years. Basically, it's Megan's Law 2 with the website. That was sort of the main change for some other phenomena. Note, 2013, after SORNA had already been passed, there was a finding by the Supreme Court that Megan's Law 3 violated something called the single subject rule. This is an arcane rule of constitutional law that says when you pass something, you can't just pass a new registration statute in the middle of a law on agriculture and timber, right? You got to have one sort of general subject matter when you're passing these laws. Otherwise, it's contrary to the idea of sort of legislative deliberation, and there are constitutional provisions that prevent that from happening. So after the fact, Megan's Law 3, even though it wasn't in effect, was no good. And that might come up in your work because that means that people who are convicted of, for instance, failing to register during those time periods, sometimes will have valid constitutional claims. So that typically comes up most in terms of, and this might happen again, that someone didn't register during a particular block of time, but sometimes if they can show that the law that they were obligated to register under was ultimately unconstitutional, they can kind of get out of that criminal violation. And that also will kind of probably surface in some of, even today, because there are these disruptions in the case law where someone says, oh, this law is unconstitutional, and someone will say, hey, well, I didn't register, but I didn't have to because the law wasn't valid. So that's something you might encounter. Is there a question?
I do have a question.
Great.
Okay, so if somebody is found to be a sexually violent predator under one of the previous Megan's Law, and they come up for parole now, does that change anything for them when they have a basis to
That's a good question.
that?
So what the court found in Butler is that sexually violent predators are not subject to criminal punishment. So that ex post facto issue we had talked about, and we'll talk about that when we get into Muniz. So the answer is no. And it's not a problem, and we'll tell you why.
Yeah.
But it's a good question. Basically, because it wasn't deemed punishment, the problem with it being, its sort of history is still preserved because there wasn't some disruption in the course of the statutes that would have caused it to, if you pass a new law, generally under the criminal law, you can't retroactively subject someone for past conduct that predates the passage of the law. So if you say, I had to register, it gets to be a very weird constitutional analysis. But because SVP registration and all the terms have never been found to be criminal punishment, those old obligations have always been preserved. So the person will have to still be treated as an SVP.
Right. I think that's the key, is that the how people were deemed to be sexually violent predators and the statutory provisions related to that have generally remained pretty consistent throughout all the different statutes, and were recently deemed to be constitutional in Butler. So a defendant really wouldn't have a claim to bring. He would lose because all the constitutional arguments he would try to raise against it have already been litigated, and the statute has prevailed.
That's
So.
right. There's another question?
Yeah, I just, quick question. I mean, obviously, one of the principles is finality of judgments, and I was just wondering if you see, especially with SVPs or some of these issues coming through with PCRAs, are the courts, looking at the statute of limitations on these PCRAs? And I don't want to get through this kind of post-conviction relief act weighed in the court, or are they just letting people get back in the court to challenge these things later on?
That's the greatest question.
So that's a good question, and I think we're going to cover that a little bit later. But the short answer is, the short answer is, under Lacombe, one part of the holding of Lacombe, which was a recent case, was that these claims challenging the constitutionality of the sex offender registration statute don't have to be brought in court under a certain mechanism. So courts are entertaining challenges to these things at this point, even years after, things seem to be final. So.
And then we actually had a separate appeal that I had that piggybacked on this holding. So one of the problems is that there are limits, time restraints on bringing a claim. The PCRA generally it's a year and 30 days.
Do you guys, does everybody know what the PCRA is? Okay.
Everybody knows. So basically, eventually you can't bring any more claims. You've been in jail for a long time, your case is long over, you can't just keep bringing arguments over and over and over again. So the courts and the legal system have requirements in place that you do so within a certain time frame. Now, if there's some massive legal ruling that totally changes things and it's found to be retroactive, they can open it all up again. So that's possible. But generally what happens is, and so we were arguing these are all old claims. You can't bring in these claims. These are all time barred, right? And then there's sort of some messy case law. And then in Lacombe they were like, we're not worried about that. And we're like, okay, that's kind of crazy. And there was a separate case that was in front of the court, and we hammered it home. And I tried to. Anyway, I failed, I guess, but we made the point very clear, that this is kind of crazy. There's really no legal basis for the court to just disregard jurisdiction, but the court affirmed it. It's been kicked to the Rules Committee. So there's a Supreme Court Rules Committee, and they kind of come up with proposed rules that the Supreme Court will then presumably adopt. So it's possible that in the near future, there will be a rule that says, okay, any sex offender registration claims have to be brought under some sort of mechanism. Commonwealth Court, traditionally they were brought in Commonwealth Court. But anyway, it's one of the things that you guys are all going to have to deal with, because you might have offenders who are 25, 30 years in the registry. Well, they could walk in and file a claim tomorrow, and there's no jurisdictional limit on their ability to do that, which we'll get to that later, because there is a possibility of a whole new flood of cases that could disrupt the system pretty significantly.
So what about the offenders who were sentenced back in 91, 93? I actually have a couple of those guys, and they've asked the question of, okay, I was sentenced and convicted before Megan's Life even existed. How am I required to be on the registry? How are they able to retroactively do that?
Yeah, how that works is it's a statutory analysis. So basically, it's very weak, it's very complicated. I frankly, luckily avoided having to do these, because it's a bit of a, you have to be pretty sophisticated in terms of piecing the statutes together. But even though the past statute was passed in 1994, 95, it looped in people from the past. So as long as, if you had a 91, a 90 earlier conviction, as long as you were looped into that first statute, that Megan's Law statute, you're in. And you're just too bad, too sad, right? But then the Commonwealth Court after Muniz tried to issue an opinion and say well, it's retroactive to everybody, but the pre-94 guys, come on. And that was kind of the reasoning, and the Supreme Court said, no, that makes no sense. There was really no basis for that ruling. So there was a ruling after Muniz where they they carved out the pre-94 guys, but there was no real sound constitutional basis for that ruling, and the Supreme's overturned it per curiam in a one-word kind of order. So yeah, as long as they're in the statute, even though they're pre-94, they're in.
And this also goes to one of the big issues that's been litigated is whether the statute is punishment. Because there's no constitutional, if it's not punishment, then your conditions can change. And that's happened to many offenders, right? They were convicted during Megan's Law 2, and then they got out of jail, and they were actually now subject to whatever the requirements were, right? Megan's Law 3. If that's actual punishment, if it's considered part of a sentence, that's a problem because you're violating the ex post facto clause of the Constitution. You're changing someone's punishment after they already committed the crime. But if it's not punishment, that's constitutionally permissible. So that's been part of the dialogue this whole time, is making sure that these statutes aren't punitive, that they're a civil collateral consequence, just like your license suspension when you have a DUI, or you can't own a firearm because you're a convicted felon. It's not part of your punishment. It's a separate. I mean, it probably feels like it's part of your punishment to the person who it's happening to, but
The law
doesn't treat it that way. So.
And then just finally, SORNA, obviously 2012 to 2018. This was largely dictated by the federal Adam Walsh Act. Our understanding is that no one really wanted to change the statute. They were all pretty happy with Megan's Law 3. But what we'll talk about, and I'll kick it over to Tracy. Basically, the Fed said, hey, if you don't do what we have said you need to do, which is a very detailed federal statute that really spelled it all out, we're going to take 10% of your federal law enforcement funding. And that prompted the General Assembly to pass SORNA, and Tracy will talk about that aspect of things.
Right. So we've already talked a little bit about the Adam Walsh Act, but the key concepts of that are the federal government is trying to create a unified system, which makes a lot of sense, really, when you think about it, because the purpose of these laws is to make sure that victims and people in the community have the ability to know if there's a sexual offender in their midst. Having effective lines of communication between states and among the states makes a lot of sense, right? And especially with like the internet capabilities now, having the ability to access that information from wherever. If an offender moves to Pennsylvania from California, you still have that information without having to go to California to the clerk's office to look and see if there's a sex offender in your neighborhood. So while that, so that's kind of I think the big push there. And again, 10% of the federal law enforcement funding is contingent on compliance with the act. So that did motivate the Pennsylvania legislature to pass SORNA and make some changes. And SORNA, relative to Megan's Law 3, it definitely, it increased the number of registerable offenses. It changed the tier structure. So it definitely was sort of more expansive than the prior version.
Yeah,
In part,
the numbers went up.
Yeah.
Numbers went up. Okay. All right, so here we go. Commonwealth v. Muniz. So you guys are going to be familiar about a lot of these concepts. So what happens is, federal SORNA comes in and the statute changes. Justices on the Supreme Court, maybe a little different, and they bring a challenge and they convince the court to rule that they find the statute is punishment. Basically, the court said you went too far with SORNA. It's a very detailed, and there's like a 7-factor analysis, and then it's a very detailed opinion. Some of the findings I'll never agree with, but surprise, surprise. But some of the key features of it, and I think what we kind of ended up boiling it down to when we were arguing these cases a couple of years later before the same court, is that, well, just to give you the core holding, which I think you guys probably already kind of can anticipate. Registration constitutes criminal punishment. Retroactive application of SORNA to those who committed their offense conduct prior to the enactment date in December 2012 triggers the ex post facto clause.
And maybe it would be helpful too, just to quickly explain what the Muniz
Did I skip it?
situation was.
Sorry, guys. Sorry.
Yeah, go ahead. Just who Muniz was and how
Sure.
these kind of came
So
about.
yeah, Muniz was convicted of molesting his 12-year-old stepdaughter, I believe. And then he absconded for 7 years. and then he captured it in Rhode Island. They brought him back, and that was the court didn't make a big deal out of those facts in their opinion, but that was sort of the scenario for how the case was presented.
Right. And so his offense conduct, and by the way, that, as I think you all probably already know, the date of the offense conduct is kind of like the key date. It doesn't matter.
Not the date of the conviction.
Right. It doesn't matter when you were convicted or sentenced. The relevant date for purposes of the statute is when you committed the conduct. So he committed his offense conduct, I believe, prior to SORNA, so either during Megan's Law 3 or Megan's Law 2 or something, and then he disappeared before sentencing for like 7 years, just before sentencing, right?
Mm-hmm. That's right.
And then he gets caught, and so he gets caught, and he's now subject to different type of registration than he would have been subject to if he had actually bothered to show up for his sentencing back in whatever it was. So.
Yeah. So the core holding that the court had, and what was another, what we would say, sort of problem with the ruling is that I think he was a Tier 3 offender, but the court was analyzing the statute what they would call in a facial fashion, meaning they're not really going to focus on the individual offender. They're going to look at the whole thing and how it works and make a determination about whether it's unconstitutional, regardless of whether some of those rationales even apply to this offender. So what the court was really zeroing in on is the idea that, okay, you've got too many people on the registry, some of whom have been convicted of offenses that don't even involve a sexual element. They're oftentimes exposed to criminal punishment that is relatively minor, a relatively short probationary sentence for like a misdemeanor level crime, but they're going to have to register for 15 years or more. And so the court essentially found that, going through this sort of technical analysis, that it's overly expansive and not proportionate to the purpose of the statute. Also, the court looked at the various in-person recording requirements 4 times a year, when certain events would happen, like if they change their job or their residence, and they found that it constituted an affirmative disability or restraint comparable to probation or parole. So they basically said you've got these people are having to effectively behave as if they're subject to parole or probation. Parole or probation are traditional forms of punishment, so this is akin to traditional forms of punishment, which adds to the analysis that there's actually a criminal punishment rather than a collateral consequence. And also an important part was the website. So they said that posting personal information on a website is comparable to colonial era shaming punishments. I will never agree with this analysis. It is what it is. But basically, that because you're disseminating information about these individuals, it's like putting someone in the stocks in the olden days. And therefore, and again, putting together a whole raft of findings by the court, ultimately they conclude that the statute is punishment and therefore can't be applied retroactively to people pre-2012, which triggers a wave of chaos in courts. You've got appellate courts, trial courts, finding the statute unconstitutional for various different reasons. People bringing claims. I'm sure you probably encountered these. People trying to get off the registry, orders coming in from all over the place, and it's kind of a mess.
And the Supreme Court, when they decided Muniz, I don't know if it was intentional or an oversight, but they really didn't give anybody any guidance. They just said, well, this is unconstitutional, it violates the ex post facto clause, so good luck to you, Commonwealth. And so it really, it led to Butler, which Carson will talk about, which was the case involving SVPs, that was really confused. The Superior Court issued a really ultimately bad ruling, but it was a published opinion, and then
kind of understandable.
Yeah.
And it wasn't just that. We had OAG Civil was appearing in criminal cases all over the Commonwealth. Okay, on behalf of the state police, that was happening. And then DAs are dealing with these claims. They have no clue what's going on. Judges are issuing 8-page opinions finding the statute unconstitutional, which is crazy.
And defense attorneys, with all due respect to Carson, who now is one, but defense attorneys have no idea what they're talking about.
Jump claims.
and are just coming into court. And, there's
putting it on the table.
Yeah, there's one defender in the Philadelphia Defender Association who's sort of masterminding these massive briefs that are getting disseminated all over the Commonwealth, which nobody but him understands. And waving them around in courtrooms, and it's really, it was very chaotic in the courtrooms.
And what added to that was the Butler opinion. So a couple months after Muniz, Superior Court enters an order sua sponte, meaning it wasn't even really briefed or argued by the parties, but the court concluded that because registration is punishment under Muniz, then it's punishment under the Aprendi concept. And that's what we had talked about earlier, the idea that because in an SVP hearing, a judge reaches its ruling by a clear and convincing standard and without a jury, it violates the requirement that any fact finding that it could increase punishment must be submitted to a jury and found beyond a reasonable doubt. And therefore, the court says there shall be no more SVP hearings in the Commonwealth of Pennsylvania. Again, adding to the chaos. And then the Superior Court ruling is ultimately the Supreme Court agrees to hear it. The Butler County District Attorney very gratefully FedExes me the file because they want absolutely nothing to do with it. And then again, one thing we were confronting, and I worked with many of these fine lawyers on these issues, is like, what the heck do we do now? Right? Because there's, even understanding these earlier opinions is a real task. Trying to strategize, anticipate what the courts are going to do. What are they concerned about? What do we do here? It became a comprehensive project that I was lucky to be involved in with a lot of fine lawyers like Tracy, district attorneys all over the Commonwealth, great lawyers with the OVA and the state police, and OAG Civil had a huge role. Traditionally, these claims have been brought in Commonwealth court because they were collateral consequences. So they fell within the the Commonwealth court jurisdiction. So there's a whole army of lawyers in OAG Civil that are extremely sophisticated on registration. Heck, they're running all over the Commonwealth, not even telling anybody they're doing it. So it was just sort of this kind of wild circumstance of trying to get a grasp on the chaos. And in the meanwhile, of course, we're getting calls from all you good people saying, the people we work with are in a panic because, their offender, or they're being told has been removed from the registry. And what the heck's going on? And, is the SVP system going to collapse? What do we do? Do we have hearings anymore? And there are some counties where the courts are like, I don't care. They're doing them. There are other ones where they're not. And even within county to county jurisdictional districts, everyone's just kind of doing their thing, trying to make sense of it. We have lawyers that would practice in certain parts of the Commonwealth where nothing had ever changed at all. Like it never happened. And you go to a county like Montgomery County where Tracy was, and it was like bedlam. So, not Tracy's fault. But, it was a fascinating and extremely disrupted kind of reality.
Sorry, I'm behind the slides here. Okay, so the General Assembly response. And, to be fair, as soon as the Muniz decision came down, the General Assembly was on it and was working on it and trying to come up with, some statutory provisions that would avoid the Muniz problem. And they managed to do that initially. They passed something in February of 2018, which was called Act 10. And then in June of 2018, they passed Act 29, which replaced Act 10. And it was really the same thing. It just, I think they passed it as its own bill, so as to avoid that problem that Carson talked about earlier that Megan's Law 3 had, where it was passed with like some other legislation at the same time. So they passed Act 29 as its own freestanding bill, and it was the same as Act 10. In any event, what Act 29 did is it divided the statute into two subchapters. Subchapter H and Subchapter I. Subchapter I is the statute that governs all offenders whose offense conduct happened post December 20th, 2012. And that date is relevant because that is when SORNA, Pennsylvania's SORNA law, was passed and had replaced Megan's Law 3. So that was the law that was problematic under Muniz. Subchapter H is basically what replaces that. And to be perfectly honest, it's not all that different in substance from SORNA. It has reduced the amount of registration and the frequency of registration for certain types of offenders. And there have been a few other changes that were made to make it non-punitive, hopefully in the eyes of the court. And by the way, the legislature, when it passed these, as part of its legislative findings, when it passed them, it stated that the purpose of this law This is a non-punitive law. The purpose is to provide, members of the community with protection from recidivist offenders, people who are, highly likely to reoffend, and to provide the community with the ability to know about this and protect themselves. And that was true for both subchapter H and subchapter I, and that's the point. And the legislature also specifically, explicitly said, we are passing this to respond to Muniz and to Butler. So they made it very clear that their intent was to have this be not punishment, but a civil collateral statute. So subchapter I is the statute that governs offense conduct that occurred prior to December 20th, 2012. And basically, in a nutshell, what subchapter I did was kind of took the statute back to more or less Megan's Law 2. Megan's Law 2 had several revisions during the course of it, but it basically took it back to a version of Megan's Law 2, which means there's a 10-year registration period, a lifetime registration period, there's a narrower list of registerable offenses. And again, the SVP provisions remain basically the same throughout all of these statutes, but including in the new Act 29 subchapters H and subchapter I.
And you kind of see the point, right? We got to fix the retroactivity issue. That's the real problem, because all the pre-2012 guys are arguably not having to register. So with subchapter I, they really went a lot further. Right? We got to make sure that we can satisfy that the court is going to see, well, all the problems they identified we're going to fix, right? With H, maybe not so much. Right? I mean, the concern isn't there because the retroactivity issue isn't there. It doesn't mean the statute was, or even now, if it's found to be punitive, there could be some possible consequences, but it's not apparent there's the same sort of risk if it's even found to be punitive. Because as long as it's going forward, it's fine. Right? I mean, there's no problem with it being punishment, as long as it's applied to people after the passage of the statute.
So I think that's a good point.
Yeah.
I mean, registration could be part of punishment. It just, as we talked about, that implicates a bunch of constitutional protections, and so that's when things get complicated. So when it's seen as a civil consequence, that makes it a lot easier.
Yeah. And also part of what's driving the legislature is that there's a provision in the federal law that says we're going to take your 10% away if you don't do what we say. That there's a provision in there that says, well, okay, you can come as close as you can, as long as there's a state Supreme Court opinion that says you can't do what we say. So there's basically there's a flexibility in that statute, but then General Assembly is in task with okay, we got to show the feds we're going as far as we can to comply with the federal rule, and we'll be able to keep our 10%. So I think part of that subchapter H, I guess, the preservation of a lot of those same terms in SORNA were an effort to try and maintain that 10% of funding from the feds.
Right.
Does that make sense? The influence is the way that they craft the statutes. They're going to go as far as they have to comply with our Supreme Court, but no further in order to keep their federal funding.
Right. So they're walking a pretty tight line. The
Yeah.
other thing that I don't want to forget, but we will come back to later, is they added a 25-year removal mechanism. And we do want to talk about that because I think that'll be pretty relevant for you guys. But basically, over the years, that had been a criticism of the statute that the court had made, but had not deemed it unconstitutional without it. But they added a provision that basically said after 25 years on the registry, registrants can petition to be removed. And we'll talk about that later, like the specifics of that in a few slides. So as we were talking about the mayhem that was ensuing, one of the cases that contributed to that mayhem is this case called Commonwealth versus Torsilleri. And real quick, George Torchieri was a 20-something guy in Westchester who went out one evening with the victim and some friends, and they all were hanging out all evening and had some drinks, and ended up back at a friend's house where he then sexually assaulted the victim who was sleeping on the couch. She reported it immediately, and an investigation ensued, and he was arrested and charged. So he was someone who had, my recollection is he had no prior criminal history. He was employed. He was, he sort of had a history that apparently was somewhat sympathetic to the Chester County Common Pleas judge and or court staff. But he was tried by a jury, and the defense made a motion for judgment of acquittal on, I guess it was a rape charge, maybe. I don't recall the exact charges, and the court acquitted him of that, and so the case only went to the jury on a lesser charge, but he was convicted and ultimately required to register under SORNA. And his offense conduct occurred during SORNA, so there was no retroactivity. So he, when it's time for him to have to register, he files a post-sentence motion saying the statute's unconstitutional. And I think I mentioned that defender in Philadelphia. He's certainly involved in the case now. I think he was involved in the case then. But he, files some post-sentence motion raising all sorts of claims about why the statute is unconstitutional. And of course, at this point, we have subchapter H. So the defendant is subject to subchapter H at this point, not SORNA, but like we said, it's fairly similar. So they make this challenge on all sorts of constitutional grounds, including a right to reputation, like separation of powers, basically the kitchen sink of, constitutional challenges they throw in there. And what happens is the court holds a hearing, and at the hearing, the defendants attempt to introduce some studies which say, basically, sex offenders aren't particularly likely to recidivize, and the science has now changed, and whatever the legislature relied on when they found, as part of their findings, that sex offenders have a high rate of recidivism, that's no good anymore. Things are changing, and this statute, which is based on that legislative presumption, it is no good because that presumption is no good either. And Carson, jump in if you want to.
Yeah, so basically,
Explain that
I mean, the idea is that, and I've terrorized Tracy with my ranting about the logic of the opinion and all of that, and it's all going now, just so you know. She's actually still doing it. I'm now off doing other things. But basically the idea is the statute's based on the idea of recidivism. There are all these social science studies that show that recidivism is actually not higher among sex offenders, it's actually lower. And it's kind of part of that whole, there's a body of academics and lawyers and advocates who are very critical and skeptical of the registration system. The idea that sex offenders are in fact a danger to society, that the registration system is an actual harm to them, it's a harm to society, that there are all these flaws, these social science studies and flaws that show that the whole system is actually based on errors and incorrect assumptions and all of this sort of stuff. Like there are for every other type of criminal justice issue. Right? I mean, there's a debate like this going on all over, but regardless, they submit these studies. The DA's office looks to a portion of the Muniz opinion that says the courts don't look at this stuff. It's not their business what the policy concerns are. That's for the General Assembly. Right? The courts aren't going to generally overturn statutes based on a disagreement on a policy determination that General Assembly should be making. Right? The court says we're not even going to look at this stuff. And so they say, hey, look, Judge, they can submit these, but they don't matter. They're irrelevant. This is not something the court can even look at. So they don't even really offer anything to counter what had been submitted. The court embraces the defense theory in total, issues a 80, 90-page opinion, embracing the idea that basically because there's a statement in the statute that says recidivism is high among sex offenders. They've submitted studies that show that that's not true. The statute therefore imposes a presumption on these people that they're recidivists and they are not, that is, here we go, also communicated to the public and violates their reputation clause claim, right? Their reputation clause rights, we talked about that. And that there's no due process to rebut the government's representations to the public about the fact that they are recidivists. So it also goes to the idea of whether tier-based registration systems are legitimate, as opposed to a specific individual risk assessment type system, which do exist, like New Jersey, for instance. They make an individual individualized risk assessment as part of their system, and they'll tier people within their system based on those findings. So if you're deemed to be like the lowest level of risk, then you're not on the website in New Jersey. Torchieri moved to New Jersey. He's not on the website. He's not even on any website at this point, but he still gets to pursue his case. That's another thing.
That's a whole other story.
That's a whole other story.
But you know, basically the concept is, you know, he committed this offense. He didn't feel that he was particularly likely to recidivate. And it didn't seem fair that George Torsolite has to now be on this website that anybody can look at for however long he's on it and find out that he was convicted of a sex offense and has to register. So the judge agreed with him and issued this opinion that then, I kid you not, literally defense attorneys would come into court holding it and saying, you know, like I was in Montgomery County saying, Judge, have you read Judge Sarcion's opinion from Chester County? The statute's unconstitutional. Now, they didn't really have any idea what they were talking about, and anyway, but you know, it was happening all over the Commonwealth, and people didn't know what was going on. So what happens is the judge does declare that the statute's unconstitutional, and the Commonwealth appeals directly to the Supreme Court.
It doesn't have the same reverberation, though. I don't know any other county court that adopted the same ruling. And because it was just a county court, it had no precedential authority over any other court. So if it would come from the Superior Court as a reported opinion in the Supreme Court, like with Butler, arguably, or you know, generally, all the Commonwealth Court, common pleas courts are then obligated to comply with that precedent. Because it's a one-off judge in Chester County, maybe within the county, depending on how their county works, it doesn't mean anybody else has to go along with what he says. And it didn't get traction anywhere that I ever saw. No other court I ever saw also agreed with Judge Sarcione and adopted the same opinion in any other cases.
Yeah.
So it was a big problem, went up to the Supreme Court, but it didn't have the same kind of fallout that some of the other rulings did.
Right. So
But that remains to be seen because it's kind of still
still going on. So at the same time, there were two cases that I actually handled in Montgomery County, Lacombe and Whitmire, and switch the slides here. So Lacombe was a police officer who sexually assaulted two people while he was on duty back in 1997. And he was sentenced, he was convicted and sentenced, and under whatever version of Megan's Law, I believe it was Megan's Law 3, but I don't remember off the top of my head, he would have been subject to like a 10 or 15 year period of registration when he got out. But it ended up that he served a pretty lengthy prison sentence, and he was released, I want to say in like 2005, and, that's it. He was originally Megan's Law 2. When he got out, he was Megan's Law 3, and then he was SORNA, and then under the new statute, he had become a lifetime offender. So at the time of the conviction, he was 10 year. When he files his motion in Montgomery County in 2017 or 2018, he's become a lifetime registrant. So he doesn't want to register for life. So he files a motion seeking to get off the registry. Whitmire does the same thing. He has a different set of facts. He was someone who had sexually assaulted a child over a period of time. But they both basically raise the same claim, and it's a Muniz type claim, and it's saying, you know, this isn't fair. I was originally 10 year, and then I became lifetime, and this statute is still punitive. Even though the legislature says it's not punitive anymore, it still is. So we litigate this in front of a judge in Montgomery County, Judge Carpenter, who was very interested in their argument and not so interested in mine, who deems the statute unconstitutional after arguments in two separate post-conviction type hearings. And we appeal to the Pennsylvania Supreme Court. And the big issue there is the statute punitive? Did the court fix it? I mean, you know, our position was, and they ultimately ruled in our favor, that, you know, in Muniz, you said that the new statute was too punitive, or was punitive, so the legislature fixed it. They did what you said, they fixed it, it's not punitive anymore, it's back to basically what it was before, it's not punitive.
Yeah, he says, they didn't go far enough.
Yeah.
Like that was the big question. Did the fix work or not? Is it going to satisfy the courts?
And I think at that point there's sort of this wave of these challenges happening, whether they're successful or not at that point, I think was unclear.
And even also the Superior Court never stopped issuing their rulings too. So there's all these, so when the Commonwealth loses on a constitutional claim in the trial court, the rules say you go right to the Supreme Court. If a trial court says this statute is unconstitutional, you go right to the Supremes, you skip to Superior Court. If the Commonwealth wins, you go to Superior Court. So meanwhile, there are these guys raising claims all over the Commonwealth. Most of them are losers, although they might overlap with what other courts are saying were winners. So meanwhile, the Superior Court is issuing all these opinions. Some of them are reported opinions, meaning they have precedential authority, and they're all over the place. And every time you read one, some of them are like 25 pages of very thoughtful, in-depth analysis. Some of them are like 5 pages. Every time you read one, there's like 27 questions that are unanswered. So that's contributing to it as well, because the Superior Court, they were unabated. They kept doing their thing. And again, that added to the confusion because there were so many layers of issues that were all waiting for the Supreme Court to finally issue some opinions to resolve these issues so that there can be some stability.
And incidentally, I litigated this exact same issue in the Cosby case in front of a different judge in Montgomery County, Judge O'Neill, who found that the statute was constitutional. So this was happening at the exact same time. So in the same courthouse, in the same county, we have one judge saying it's unconstitutional and one judge saying it's not. And both involve subchapter I, so offense conduct that occurred prior to 2012. So we get to the Supreme Court. As I said, we win Lacombe and Whitmire on the punitive question. There was another question, and counsel, you had asked about this before, this PCRA issue. So one of the arguments we made in Lacombe was that his claim was a claim that was brought under the PCRA. So there's specific requirements for post-conviction claims, and if a claim is cognizable, if it's recognized as a claim that can be brought under the PCRA, like it's brought under the PCRA. And so we made that argument because he was saying that registration was part of his sentence, and sentencing related claims fall under the PCRA. So that was an argument we made. That as a PCRA, it was untimely because he's bringing it years and years and years after he would have been allowed to bring something under the PCRA. Well, the court didn't really want to hear argument on that point at the oral argument, and then as part of the opinion, basically found that these defendants, they're not restricted to bringing these claims under the PCRA. They kind of can do whatever they want, bring them under anything, which is really a problem because it sort of opens the door for these to be brought through any mechanism years later. So that was an unfortunate fallout of the Lacombe.
Yeah, and then they did the Butler case. This is when former Deputy Attorney General Carson Morris saved the SOAB from extinction. But the thing with Butler, Annette used to come in my office and sit there, and she's like, "Oh my God, what's going to happen?" I'm like, "That's fine, we got it. Don't worry about it." I was like totally confident, just like deluded myself. But everybody did. And when I argued the case in Pittsburgh in front of the court, I thought I was going to get destroyed. Everybody said we were going to get crushed, and the court agreed with everything we said. It was the weirdest thing. I thought I was going to get wrecked, but everybody in the state police, the civil division, all the DAs, and even within the office, the victim advocate. But it'll talk about how it illustrates, I think, what the issues were for the court and how so much of those rulings that were happening all over the Commonwealth and all this chaos was really based on a misinterpretation, frankly, of what the court was communicating to the Commonwealth in the Muniz opinion.
Yeah, and again, what Carson said is true. Because if not for the work of people like Carson and Tracy, there probably may not be an SOAB, because that would have taken away the SVP authority to do those assessments as well, and the NRHR, which Carson argued as well, where the Superior Court found that the Act 21 was unconstitutional under the Muniz case. And really, the only comment I was making, it was just, when I remember having kind of the agita when all these cases were going through, especially Butler. But, and I don't know if you want to comment, my comment would be this: I found it frustrating. when I saw Muniz come out, I saw it, I said, well, that's pretty bad, but it may just be with registration, there could be registration fixed, go back to Megan's Law 2, and then that'll be it. But then when Butler came out, and then with NRAJC, you see almost Superior Court just taking Muniz and going Muniz plus, going further and further out. And that was kind of frustrating. Do you think there was an issue with that?
Yeah, I think a lot of it in the Superior Court was just judge specific. There are really smart, fantastic judges in the Superior Court that people like me, you go back and you read all these old opinions, that they kind of have a view on things. And it's well founded. I mean, they're very sophisticated, very smart judges. But some of them kind of have a history of being a little skeptical towards these statutes. And they'll issue opinions and they'll have dissents and concurrences and stuff like that where, and I think a lot of it was almost coincidental. I mean, you had judges, Judge Bender was involved, he was part of the Butler ruling, and then he was on the JC thing where he, we'll talk about that in a sec, where he basically issued an opinion overruling another 3-judge panel, which is categorically against the rules, and then triggered a non-banc ruling to try and kind of get Act 21 tossed. So I mean, there was, I think it was a complicated mix of personalities and very sincerely held and sophisticated views on the law by a lot of the Superior Court judges. And I think kind of how I read Butler was like, hey, Supreme Court, look what you did. You were so clever finding it to be, and this is all speculation. I mean, I don't know this, but it's what everyone who read it was like, yeah, it was kind of like the hi-hat to the Supreme Court, because it's like, well, did you know that by finding that it would be punishment, that means there's no more SVPs? I mean, it was almost the way that it's written, it's like, well, A, B, C, then D. Bye. You know what I mean? It was sort of this, so it's kind of interesting to read through the lines, and who the heck knows? I don't know. But ultimately in Butler, we got to get too off track, we were able to convince the court, well, the one that, like, the real concern that the court had in Muniz was the idea of too many people on the registry that shouldn't be on the registry, and then sort of disproportionate treatment, right? That was really the core. And that's what we ended up focusing on in the oral argument. That's really what the real message was. And I think we captured that was really what the court was all about. Well, if you're a sexually violent predator, you need to be on the registry, right?
You're in a whole other category.
That concern is absent. And then we did a 80-page, very sophisticated, detailed analysis from God knows how many hours of work, showing that once someone is categorized as a sexually violent predator, the norm around the country is like civil commitment, right? I mean, compare what we do to that. And there was a lot of on-point United States Supreme Court precedent around the country, that the idea that once someone is a sexually violent predator, that system had been affirmed over and over and over again in past case law, then they're in a different world. And you can't compare A and B. And the rationale in Muniz did not apply to sexually violent predators. And in fact, the court in Muniz distinguished their analysis from the analysis applicable to sexually violent predators. And the court just got it wrong by taking Muniz and extrapolating from that also sexually violent predator registration was punishment. And then there's a whole bunch of other stuff. So basically the court unanimously, shockingly, agreed. And then the system is sound and safe, and it should be for the foreseeable future. So that was a big win. The same parallel to that is Act 21. Who knows what Act 21 is? Give me some hands. You're the only people in the Commonwealth to know, the 4 of you. So it's this obscure statute that's absolutely fascinating. When juveniles age out of the juvenile system, if they're committed pursuant to sort of very serious sexual conduct, and they're still in an inpatient facility when they are aging out of 2021, they get evaluated by the SOAB, and a determination is made as, can this person be released out into the community and not pose a risk to the public, essentially. And there's about 60 or more so gentlemen in this program. It's based in Torrance. There's an inpatient facility. And these guys are they're the reason we have registration. I mean, their stories are horrific. I mean, many of them, the trauma that they experienced as children, I mean, the damage that has been done to them is just staggering. And they literally cannot function in society without committing sexually violent acts. They do not have the capacity. And they've been in the juvenile system, and basically the point when they would otherwise be going out, the court says, okay, this person does not have the capacity to live and be safe to themselves and others. And they go to this program. And it's amazing. I mean, it's like 24 hours a day, very intensive therapy. The people who work there are extraordinary, the commitment that they have to helping these young men. And many of them have been there for a very long time. And who knows if they'll ever get out? It's a very complicated kind of situation. But they work tirelessly to help these men, and some of them have progressed to the point where they can actually go back into society. And even those guys are not exactly cured, I can promise you. So that was the issue, whether sort of piggybacking on the Butler rationale. If you're going to commit someone to a facility, then that would also violate the idea that that's to be done by a judge, because that also is determined by a judge at a clear convincing standard, similar to the SVP analysis. And then again, the court for Butler, plus a bunch of other reasons for why a mental health commitment essentially is not criminal punishment. The court basically piggybacked on Butler and ultimately found that that statute's not punishment and it's also sound, which would have been a public safety emergency. They had to release these men. I mean, it would have really been, I don't know what, it happened when the Kids for Cash thing, you guys know about that? A couple of them got out pursuant to the Kids for Cash because their underlying adjudication was invalidated. And they kind of came up with like a 302, like wink, wink, nudge, nudge, where they committed them to a different facility under 302, and everyone didn't appeal. I think because all the actors were like, oh my God, if these guys get out, it's gonna be a real problem. But I know that at least one of them has gotten out, and there were some issues with him because he had surprise, surprise, moved in with a woman who had kids, and that they were trying to deal with that. I think that was going through the Children Youth Services. But it has been an issue. So some of them have gotten out that have, are not, cured, quote cured, but it's only happened in a few occasions.
Okay. So we're starting to get a little low on time,
Yeah,
so we're going to try
I'm
to move. No, we like hearing you, Carson. I just want to try to move a little bit quickly here. So questions going forward, things are still pretty unsettled. At this point, we know that subchapter I is constitutional in that it's not punitive and doesn't violate the ex post facto clause. But Torsolite was remanded. So the court never decided it, the Supreme Court. They remanded it for a hearing. And what happened was Carson brilliantly found an article. Wasn't it the dark figure of recidivism?
Oh yeah, I did.
So found an article. He was working with the Chester County DA's office and the civil division at the AG's office on the Torchieri appeal, and he found an article that was published right around when we were submitting the briefs called The Dark Figure of Recidivism. And what it talked about was the idea that so many of these crimes are not accounted for when you count figures of recidivism because they're not reported. Or, for example, if you count recidivism as a new arrest, that's not the same in my mind as actually recidivating, which is committing a new act. So
Counterpoint to the studies that have been submitted by the defense.
Exactly. So we submitted that during the appeal, and what the Supreme Court ended up doing was it said, we're going to send this back to the trial court. This isn't for us to decide. There's some factual issues here about whether there's a scientific consensus about whether sexual offenders really do, recidivate at a high rate. So we're going to send that back down. So that was sent back down, and in the meantime, the Superior Court has also been remanding a bunch of cases along the same lines. So now in counties throughout the Commonwealth, cases are being sent down for hearings on this question: is there a scientific consensus about sex offender recidivism rates, and is tier-based registration the right way to do this? We had the hearing in Torsolite a couple of weeks ago at the end of June. So Aaron O'Brien, who is a really great assistant DA in Chester County, handled it, and there were 3 experts who testified for the defense, and then the Commonwealth had 1 expert. And it was a 3-day hearing, and I would say my summary of it, and I was at the hearing the entire time. My summary of it is that the defense experts came in, and they're generally, I would say, fairly biased, and they came in and said, these statutes don't prevent recidivism. And that's all fine and good because, as we said before, the purpose of these statutes isn't to prevent recidivism. It's not to prevent people, offenders, from reoffending. It's to provide information to members of the community about these offenders so they can choose, how best to protect themselves. We had an expert too who came in and basically said, all these studies that the defense are citing about recidivism are wrong, and and weren't done correctly. That is still very much in the middle of litigation. We'll be doing post-hearing briefing on that, and then the Chester County judge will make a ruling, and then one or the other party will appeal it, and it'll go from there. So that's going to remain unsettled for some time. But because of those issues, the Pennsylvania District Attorneys Association decided to file a King's Bench petition because these cases are popping up everywhere, and the experts, they're very expensive, and a county with one DA cannot afford to bring in a $60,000 expert to come in and talk about recidivism. So
and the defense bar as well.
right.
The hearings presume thousands and thousands of dollars in very technical expert testimony,
Right.
which courts don't want to do, but they have the burden because they've been remanded, and they kind of like, what are we going to do about these hearings?
Right.
So
So the idea is all these courts in the Commonwealth of Pennsylvania and all these different judges could be making rulings on the same factual findings. The same idea about are sex offenders highly likely to recidivate. And by the way, the defense experts all agreed that the recidivism rate, the risk of reoffense for sex offenders is higher than that of non-sex offenders. So in my opinion, that should be a winning argument for us later on down the road, because that's all the legislature has presumed in the legislative findings that are part of the statute. So anyway, so the PDAA filed this King's Bench petition asking the Supreme Court, basically saying, you created this problem, we have all this stuff going on, you helped us fix it. So we asked them, or the PDAA asked them to either appoint a special master, like one judge to hold an evidentiary hearing, or a panel of judges from different counties to hold the evidentiary hearing. The Supreme Court conveniently did not rule on that prior to Torchieri, so the Torchieri hearing went ahead. It's still pending. No one really has any idea what they're going to do with it. It's kind of annoying, but a lot of counties right now are just putting stuff on hold pending the decision on the King's Bench. So it's not very helpful for victims, but that's kind of what's going on there. Things are just kind of on hold. So
quick is Muhammad. Muhammad, anybody encountered this? You heard this? So, meanwhile, one of those statutes that the court didn't like was the statute where interference with the custody of a child. So there's a registration statute that requires registration. That's one of the ones that wouldn't necessarily involve a sexual element, right? A dispute between parents over a kid under the old statute could be charged and convicted, like they take their kid from the other kid, interference with the custody of a child, right? And that could make them register, but there wouldn't be any overtly, at least, sexual element in the statute. Although I think Megan told us that almost always does have a sexual element, right? In the actual cases. Who did that?
No.
Someone told me that. Anyway, maybe it was Annette, I don't remember. Anyway, so that was one of the statutes they don't like, right? Great. So they fixed that a little bit by taking the parental element out of it. But there's a case in Reading where like the girlfriend of the boyfriend takes the daughter from the wife in this kind of melee in the streets, grabbing kids, driving cars, custody dispute nonsense. So she's convicted and has to register. And she raises a as-applied challenge to her reputation clause registration obligation. So which is sort of like the flip side of what they're trying to get in Torsolite. They want Torsolite for the courts to basically say, you have to look at me individually and say whether or not I'm a risk of sexual recidivism or a sexual risk before you can make me register. They raise those arguments. The Superior Court issues a reported opinion endorsing the argument. The argument's clearly wrong, in my opinion. I think it's like bad facts resulting in bad law, basically. I ranted and raved about the DA's office continuing to challenge this opinion to all these good people and tried everything I could, and the DA declined to continue to challenge it. So that is the prevailing law. What that means is that because of the jurisdictional issue, any offender in Pennsylvania can file an as-applied challenge and say that I am not a recidivism risk, and therefore you have to remove me under my reputation clause claim. And they can get a couple experts to say this person's not a threat and file a petition any time of the week if they've been on the registry for 20 years and arguably should have an individualized right to a hearing and can challenge their own registration obligation. These have been filed, they're happening, and you might see them. You might encounter them. So this is another major problem with the, a bad ruling, and it's out there, and the problem is it's not getting challenged from that case because the DA declined to do so, but it almost certainly will find its way through the courts through a different case. Right? Some other guy in some other county will try and do the same thing. The DA's office will oppose it, and it'll make its way up to the courts through that mechanism.
So like, for example, in Monroe County right now, there are like 10 or something cases where all the defendants are challenging the statute. They're saying it's unconstitutional in general.
And under Muhammad.
So they want to have a hearing where we have a bunch of experts battle it out on, do sex offenders recidivate, and then they each want an individualized hearing with a bunch of experts to say,
Last thing, 25-year removal. Before we have a couple minutes. Okay, you guys are familiar with this? They added this to both statutes for SVPs and non-SVPs. No one exactly knows what this is going to look like, all right? Because it's not until 25 years. Although people who have been on it in the past could arguably have one coming up soon.
Right.
So basically, after 25 years, we have no problems, no violations, no crimes. You're a perfect citizen. You can go and you can petition a court to remove you from the registry in whole or in part. They can reduce the conditions. They can take you off completely. Basically, you get to challenge your registration obligations. If you lose, you get every 5 years. You can keep filing them. SOAB does an evaluation, I believe. Sorry, that you have the information to go through it in detail. And basically, it sort of starts this review process. No one really knows what it's going to look like. We're not really sure whether the victims will have a say in that. We think that there might be room in the sort of rule, right? Where do we see that?
Right.
On page 25?
Yeah, on
26.
Page 26 of the slides. I mean, under the Crime Victims Bill of Rights, crime victims, have the right to be notified of certain significant actions and proceedings within the criminal and juvenile justice system.
Arguably, this is not, right? Because it's collateral, not criminal.
But arguably it is. So, I think there's some room there. And to not be excluded from any criminal proceeding. Now, this is not a criminal proceeding, as you said, it's a civil type proceeding, but, I think arguably it's relevant. And I think the SOAB, as I understand it, the statute sort of gives the SOAB, the ability to sort of determine how to do these. And so I think the SOAB could potentially incorporate victims.
Which the defense bar will resist vehemently, I can promise you. As a member of the defense bar. I never want the victim in the room. You guys know that.
So we're basically out of time, and I want to
Pretty much over
time. Yeah, with the 25-year removal mechanism. But our contact information is on here. I'm happy to stick around if anybody has any particular questions or anything they want to ask. Thank you so much for having us. I hope it wasn't too boring. This stuff can be pretty dense, but we think it's pretty interesting once you.
So now it's totally Tracy's responsibility, by the way, to preserve all these statutes. I have absolved myself.
So if it doesn't.
Although if the government wants to hire me, they probably could do that. I'm sure that would be doable. Now that they have Tracy, they don't need me.
Yeah.
So.
But again, any questions or anything, please feel free to contact me. I brought some cards too, which have my cell phone number on them. If things come up, if someone's starting to have someone's doing a 25-year hearing and you have questions about what you think would be the right way to go about it, please feel free to contact me.
And Tracy's a good contact because the OAG, they can connect to people around the Commonwealth. So if you have like a far-off case in some county with the DA, generally the OAG can be a good clearinghouse for that kind of stuff to connect to the right people that can get the resources that are necessary.
Thank you guys. Thank you so much.